one of the things he said to he said, "I've been living a lie for 30 years. I've always told people I have an MBA," and he didn't have an MBA. And
Oh,
then,
no.
and then he tried to tell me in the mediation that it was a typo. I said, no, you don't want your fingers just went to MBA.
Welcome to Water Cooler Justice. I'm Chris Robertson. I've been practicing employment law for over 20 years, helping clients resolve disputes or navigate challenges at work.
And I'm Sarah Goodenough, Chris's legal assistant.
So today's guest list is another fantastic list. We know Barry is the Dean of Employment Law here. His blog is a must-read for anyone practicing or interested in employment law. He's a mediator and an arbitrator in Toronto and brings over 30 years of experience as an employment lawyer and legal author to our show today. Stuart Rudner is the managing partner at Rudner Law, a trained mediator, an expert in alternative dispute resolution. He approaches employment matters with neutrality, aiming to achieve fair outcomes for all of the parties involved. He's the perfect guest for today's discussion about just cause, having authored the book, You're Fired! Just Cause for Dismissal in Canada. We're happy to have you both here today. Thanks for joining us so much.
Thanks for having me and pronouncing "You're Fired" the way it was meant to be pronounced.
Well, if you put an exclamation mark in the title, that's how I'm saying it.
So to get started, I'm going to share some details of a recent case. We're going to discuss each issue and then discuss what you each think a fair judgment is. I'm also going to share the judge's decision at the end, so we'll find out the resolution. Shall we get into it?
Sounds good.
Our story today takes place in beautiful British Columbia. In May 2020, Mr. Mechalchuk accepted a senior employment position with Galaxy Motors and signed a contract of employment. Mr. Mechalchuk rose swiftly through the ranks, and at the end of his termination, his title was President of Operations, making him the most senior non-owner employee of the company. He was earning between $750,000 and $1 million at the time of his termination. So a few other key players. Galaxy Motors was owned by Mr. Phil Dagger. Mr. Dagger's niece, Mrs. Jones, was also employed at the company as assistant general manager. In August 2021, Mr. Dagger died unexpectedly. Galaxy Motors was inherited by Mrs. Jones and her brother, Mr. Mark Jones, shortly thereafter. Mr. Mechalchuk was given signing authority for the company. On June 15, 2022, the plaintiff was on a business trip on the Parksview area of Vancouver Island. He was accompanied by his wife, and the two of them had dinner and breakfast together at a restaurant in the area. He wrote the names of 2 employees on the restaurant receipts and submitted them for reimbursement to the company's in-house financial controller. The plaintiff was reimbursed for both of these meals, which were approximately $250. Later that month, plaintiff and his wife, together with several Galaxy Motors managers and their respective spouses, attended a dinner at a brew pub. The plaintiff testified that when the dinner bill was presented, he and Mrs. Jones had a discussion during which they agreed it was a team-building event that could be justified as a business expense. He paid the bill. In her testimony, Mr. Mechalchuk's wife confirmed her husband's account. Mrs. Jones, however, testified that she never considered this to have been a company event, believed that the plaintiff was simply being generous when he paid the bill, and thought it was ludicrous when she learned that he had submitted it as a business expense, and she declined to approve it. Mr. Litter, the company's in-house financial controller, testified that one of the other attendees at the dinner had told him that Mrs. Jones had approved the dinner as a business expense. Now, when confronted about these expenses, the plaintiff testified during the meeting that he could not recall any discussions of the Parksview meals and was placed on a leave of absence. A couple of days later, Mrs. Jones advised the plaintiff that he was being dismissed immediately for just cause. Mrs. Jones testified that her concern about the plaintiff's integrity was bolstered by his failure to admit that the dinner and the breakfast at the Parksview restaurant had been with his wife and not the other employees. So I'd like to hear, what are your first impressions of this case?
He lost his $700,000 job this was too cheap to pay for his wife's dinner.
That's a little cold.
I hope he had a good dinner. I mean, it on the surface it looks. I think the important thing is forget about that business lunch thing, because the right thing happened there. She didn't approve it, and I guess he ate it. So I don't know why they threw that in, other than to show that she reviewed it. The other 251 got paid. I mean, he misled his employer. He put down the names of 2 employees, so that's a false document, and then he lied about it. So it was like 3 instances of dishonesty. And frankly, it's almost refreshing to see that a high standard of honesty was imposed on a senior employee. Because in the real world, I think the senior employees often get away with more crap. You have some warehouse employee who takes a pack of toilet paper home or something, and the employer talks about honesty and integrity. So it was kind of refreshing to see that a senior guy got whacked for basically $250 worth of theft.
Yeah, and I was going to say, I love this case. Like, I spend way too much of my time talking about just cause. And this case demonstrates, like, one of the things I always say is you don't just look at the alleged misconduct. Courts are looking at what they call the contextual approach, looking at all the relevant factors. This is a perfect example of it, right? This is a senior guy, the general manager, making close to $1 million a year. And there's a high expectation of trust. And so that's one factor, is the nature of the role. Second factor, and Barry kind of covered this basically, is, was it deliberate? Was it a spur of the moment thing, whatever? And the other factor that's often really important is, how does the person respond when you confront them? And employers hate it when I tell them, you got to confront them and give them a chance to explain. And they always say, what's the point? They're just going to lie anyways. And my usual response is, if they lie, they're basically digging themselves a bigger hole, because now it wasn't only misconduct, it was dishonesty. So all those things, like Barry said, kind of came into play here. And it's a perfect example of how slightly different facts, a lot of judges would look at this and said, yeah, it was misconduct, it was inappropriate, but some lesser form of discipline would have been appropriate here. In this case, as Barry put it, he got whacked because of all those factors. So it's a great case to teach people how courts are approaching these things.
Yeah, I hear that. I think I have a slightly different view. I mean, first of all, at the brew house, there's a real issue as to whether or not there was an approval on the receipt or not. And that's what led to the investigation. The investigation, there were many types of misconduct or instances of misconduct alleged, many of which, or all of which, were abandoned at trial in favor of the one Parksview event. The Parksview event was a business trip. So, it's not immediately clear to me why, if he was out for dinner with his wife on a business trip.
Why was she with him on a business
Well,
trip?
I'd like to know more context about that, right? Because she was also at the brew house pub too, right?
Mm-hmm.
So there's some stuff there. Behind this, after they terminated this employee, the 2 owner managers, the Joneses, who inherited the business, gave themselves a $358,000 bonus. So they had 358,000 reasons to be aggressive in this litigation, because they sure as heck weren't giving the bonus money back. And then, the last thing that kind of disturbs me here is there's, some proportionality required in order to achieve cause, right? McKinley and BC Tell, it's got to be termination for cause is the capital punishment of employment law. You want to see that it's not implemented lightly, or where there's confusion, right? And so the thing where I think this employee got himself into trouble, Mechalchuk got himself into trouble, was when he got called into that ambush meeting. And I'm not sure whether at the ambush meeting they were confronting him with all of the alleged misconducts, or if they were more specific. But I think that's probably where he did himself some disservice, because I can think of any number of explanations which would have explained the names on the receipts. But in owner-managed businesses, it's not uncommon to see perquisites flowing through the company that, you may or may not raise questions in a larger organization that has payroll and larger infrastructure. So, I had some thoughts about it. At the end of the day, should you lose $1 million job over a $250 dinner? Right? I have some thoughts.
Well, let me change the story then. You got a $50,000 clerk who literally takes $250. She makes $50,000 a year. It's been here a long time. she's short of cash because her grocery bill is due or something like that, and she literally takes $250 cash out of the cash register. Would you have the same reaction there?
Well, I don't think there's any element for confusion about whether or not the expense was authorized. That's the difference, right?
No, he wasn't alleging that this 250 was authorized.
Right, and I think that's, if there's a reason why he got terminated for cause and it was upheld on appeal, I think that's it. Right? I think there were explanations that probably could have been offered at the meeting, which would have put him in a better position. Too bad employees don't have.
He could have been a better liar. Is that what you're saying?
Well, there may have, according to the Court of Appeal, there was a lot of evidence that didn't make it into the trial, and maybe we'll talk about that in a little bit. But it looked to me like they were planning to prove their case largely through cross-examination of the employer's witnesses, and then the employer didn't call the witnesses because they'd made their bones on this one particular offense, right? And so that might have been some very good trial strategy.
A colleague of ours, Howard Levitt, once noted, if you ever want to get rid of someone, just go through his expense account. He wasn't whacked for the brew club, right? But it opens it up.
But you know what? I mean, just the fact that he put two employees' names on those slips, like, my view is he knew what he was doing was wrong. And then, to your point, Chris, about proportionality, but I always say, the ultimate test when a court is looking at whether there's just cause is, was the employment relationship irreparably harmed? And in this case, and I go on to talk because I like to talk, I go on to say that, it's basically whether the company can trust this guy going forward, or is he going to be a repeat offender? In this case, he didn't have a good explanation for what he did. He lied about it, and he gave them no reason to think it's not going to happen again. So to me, if it was a lower role, maybe he gets a warning. But in this case, he's the general manager, is making $1 million. To me, I think, there was no credible reason to say that they should have continued to keep him on in that role and take their chances. He's proven himself.
Did he lie in court too? What is the...
That's not clear to me. I don't know, Chris, do you know?
Well, so I read the Court of Appeal and I read the lower court decision. I won't try to summarize them all, but one thing that I did think was interesting was that his evidence specifically about the ambush meeting and what he said at the ambush meeting was evidence that the trial judge was least inclined to find credible. That was where his credibility really got challenged. And one of the explanations that he did offer at trial appears to have been that he was told to put the employee names on the receipts to keep it simple or something along those lines. And I can understand why a business or I can understand why a bookkeeper might say, yeah, put some employee names on there if they were worried that the expenses might be reviewed or denied by CRA, for example. And so if he had offered that up at the ambush meeting, would that change the factual matrix? I hope.
But again, he wasn't fired for he was fired because of the wife thing.
Right, but these are the receipts.
Oh, you mean if he said,
yeah.
Well, yeah, you got to put that down. Otherwise, we can't deduct it as
right. And
right.
I've seen this in owner-managed businesses in other employment disputes where suddenly something which the employee says was a perquisite is alleged by the employer to in fact be theft, right? And I've seen insurance companies called. I've even seen the police called. Right. And so none of that I didn't see anything about insurance and I didn't see anything about the police here either, which I'm interested. Right. Like if this was such a big deal, where's all that? And I'll tell you where it is. It's because it's not a big deal. It's only $250 for a guy who makes $1 million a year.
Cops don't care about this stuff. You can waste your time getting the police to chase one of these things. They're not going to.
Right. I'm just saying of the options available to the employer, right? They just went with cause, and they were successful. Yeah. I'm wondering, is BC a different jurisdiction from Ontario? Do you guys have any insight on that? Would Ontario courts be more lenient, or is dishonesty throughout Canada?
I mean, I'll jump in. I mean, from the cases I review cases every year to update my book, and we see cases from every province, and they're pretty consistent. So I don't see BC as being leaning one way or the other, frankly.
All right. Yeah. Barry, any other thoughts?
No, I don't think there's any regional differences.
All right.
I'm curious, Chris, you referred to it a few times as the ambush meeting. Like, was there evidence that that he was literally ambushed, or was he given some heads up?
Fair enough. I'm a plaintiff's lawyer, right? So every meeting is an ambush as far as I'm concerned. But more importantly, in these expense meetings, my read of the lower court decision sort of read like, he walked into work that day and he was told, you've got to come up for a meeting, and he was asked about specific expenses. And I think those meetings are always challenging for an employee.
Yeah, no, look, I always tell my clients, if you're going to do it, like, give the person the heads up, and you don't want to be seen as ambushing them. So I agree with you.
I don't know what purpose it serves without warning, right? If you say, hey, we went through your expense account, we saw some irregularities, we'd like to talk to you about it. I don't know that you have to give a whole lot more warning than that. You don't have to say which expenses. But if the guy asks and says, which expenses are you concerned about? And you gave him a list of 3 or 4 or 5, and he comes up and he still gives you the same answer. Well, now I'm probably where everybody else is right now. It's clearly dishonesty. Right?
So what's the smart thing to do if you're an employee and you're confronted with that? What's the smart thing to do?
I don't know. Right?
I don't recall.
If you say nothing, it looks
No, you just say I don't recall. I put in 200 expense issues. I have no recollection one way or the other eating there or anything. I guess I did, but I don't know.
Yeah. Well, I looked at it actually. I looked to see how far away the Parks View dinner was from the brew pub. It was only 30 days. It was only a month earlier. So I can remember most of the fancy dinners I've had in the last month.
How far away was the wife with the dinner from the discharge?
It was about 30 days.
Okay. Again, his problem was lying. He could have said, I brought my wife on the trip. That was allowed. Of course, when I'm going to sit there, I get to eat. I get to deduct mine, but not hers. Come on. And if you're telling me that's wrong, I won't do it in the future. So fine.
Right. That's sort of what I'm wondering. I'm wondering how that meeting didn't engender that response, right?
But at the end of the day, he had the chance. And, this is a guy, I work with employees too, so I'm not only employer side. And I always, when I'm retained by an employee in this type of circumstance, I'll say, look, bottom line is you don't want to compound your errors by being dishonest. So if you go into the meeting, if you do remember it, don't lie. Just say, like Barry said it perfectly. Well, I thought it was appropriate. If it's not, my bad, and it won't happen again. And if the key part is it won't happen again. And I think 9 times out of 10, if they do that, a court's, and assuming they've got a clean record going into it, a court's going to say, yeah, fine, give him one more chance.
I think that's right. That's why I was surprised at the outcome.
But here he didn't do that. Here he seemed to be just digging deeper by being dishonest.
I'm curious, Stuart, how often do you get retained before the meeting as opposed to after?
Are you talking about for the employer or the employee?
For the employee. Or for both, actually. I'm curious.
Yeah. Well, I mean, quite often by the employer, but in many cases by the employee. We're often consulted, and it's often urgent because I've got a meeting this afternoon or tomorrow. And sometimes I'm giving advice without having a whole lot of information, but I usually just say what I said a few minutes ago, which is there's no point in lying. If you don't remember it, you don't remember it. But if you do, then just acknowledge your mistake and give them every assurance to believe it's not going to happen again.
Or what about just refusing to answer the question because in effect they're asking you questions about criminal conduct, and the person can say, I wish to consult. You seem to be accusing me of criminal conduct, and I wish to consult with my lawyer before deciding whether to answer your question.
That might help them avoid a criminal charge, but is that going to help them avoid punitive measures in their employment?
I'm not answering the question because my lawyers told me. Because if I confess to you, that can be used by the Crown. So my lawyer has told me to shut the F up. I'm following my lawyer's advice. I'm just refusing to answer the question.
I often tell my clients, I don't get retained very often before the meetings, but when I do get retained before the meetings, I often tell my clients to ask for the questions in writing and ask for the evening can I think about it over the evening and get back to you, right? I want to talk to my wife about it. They're not talking to their wife. They're talking to me.
So you're sort of pretending to be cooperative with throwing obstacles in the way. I think this could be a useful technique.
You're entitled to know the case to meet. Like, that's a principle of natural justice, right? So walking into an ambush meeting and where were you on the day of and how come Jim's name is on here when we know Jim wasn't there? First of all, like, what if it's just a date error? Like, what if you've put the wrong date? You did have dinner with Jim, but you just got the wrong date on the receipt or the expense report.
Or,
right?
This is terrible. We're telling people how to cheat, but the other one is, you know what? I'm terrible bookkeeper. I had a whole raft of receipts. I thought that was the one with Luke and Sam. Maybe I was wrong. I
Maybe
don't,
this other one was the one with Luke and Sam,
it's
and this
called
one
the
was.
sloppy. I'll tell you,
Yeah.
I had a case once. I represented this. I had a case. I call it the sloppy bookkeeper defense. I had a guy who was what's called anyway, some sort of a delivery guy, vachon cakes. For those people from Quebec, they know what a May West and a Joey.
Now I'm
Moose
getting
are.
hungry. Yeah.
Right. So what happens is the guy loads up the
Sponsored.
truck. The guy loads up the truck with product and then and then sells it throughout the day and returns. So he leaves with $2,000 worth of product and returns at the end of the day with cash and product equal $2,000. Well, they did an audit of my guy and it was off. He was off, whatever. So they fired him. And his excuse was, I'm a bad bookkeeper. I'm poor at math. So what I actually did was I sat down with a whole year's receipts and compared them to what he reported. Now, if you're lousy at math, you're going to make mistakes both ways, right? Relatively equally. Well, this guy, his bad math only worked in his favor. So that's what I thought. Had the number of ups and downs being roughly equal, he would have had a decent defense saying, I'm just a lousy bookkeeper.
I kind of like Stuart's approach too, right? Contrition and acknowledgement, and
You're still going to get fired, though. You just may win your case, but you're going to get fired.
right.
Yeah. Well, you make it a package.
Yeah, yeah. No, you're right. You're always going to be fired. The issue is whether you get a package or not, right?
Well, but that's all you need to win on, and I think that's maybe the most important takeaway if we have one today, right? Dishonesty, once proven, it's hard. There's not a lot of room to wiggle off that hook. Once
And remember,
the
this is
dishonesty
a car
proven.
dealership too. They never cheat people. It's the epitome of the highest standard of business. Car dealers.
Would that change the context of the analysis? I
I
don't
don't
know.
know.
I was going to say,
Yeah.
I talk about contextual approach all the time. I've never considered the ethical nature of the business.
I don't know. I mean, but I've seen people try to do that. Oh, you think I'm bad? Look at what they're doing. That sort of stuff.
Yeah, I don't know that's, again, I don't think that's the test. I think once dishonesty is proven, you're in a difficult space. I often talk about this on the podcast. It's about evidence.
Or if it's differential treatment, if you could show that this was the culture of the company and they just picked on you, then you got a shot. Differential treatment can be your argument. Other people do the exact same thing and you don't discipline them. The trouble is plaintiffs often put that forward, and then in mediation I'll say, well, give me the names of the people. Or when I was employer counsel and they say, give me the names of the people. Why? Because we're going to fire them too. Thanks for telling us. And then they always climb up.
Yeah, I've tried to put the owner on the hot seat by saying, let's take a look at your expense reports. Let's take a look at the standard that's being applied. Is it being applied
Right.
evenly, right? I think that's fair. But I wanted to move on a little bit. Sarah, I wanted to talk about the next thing we were going to talk about, which is how you establish just cause and a little bit about proportionality, right?
So, in speaking of, I guess, when there is a breach of trust and we're letting someone go for that, what are some strategies that an employer would use, or what is the legal test for defining whether or not there was a breach of trust and therefore if there is just cause?
Well, it's interesting. I mean, Barry already covered one of the things I see a lot, which is the 407, filling up your spouse's, or using your 407 transponder for your spouse's car, or filling up your spouse's car with gas. Like, I see those a lot. One of the interesting cases I thought of when I was thinking about this show was dealing with the workplace romance, because there was a great case, and this is a public case. I don't remember the name of it, but I can probably find it, where the company had the right policy. The policy didn't say you can't have workplace relationships. What it said was, if you are engaged in a relationship that could create a conflict of interest, you've got to disclose it. And there were all the rumors swirling around this one senior executive and a lower level employee. And eventually someone confronted him and he said, no, we're just friends, that's it. And they confronted him again a few months later, he denied it again. And eventually they got the evidence that he had been in a long-term romantic relationship with her, and they fired him, not because of the relationship, because of the dishonesty and breach of policy. And that termination was also upheld. So to me, that's a great example of, it's the dishonesty and the repeated denial which again gave him no reason to think that he would be trustworthy going forward.
Yeah, it's the cover up. It's like the Watergate thing. The cover up is worse than the underlying crime. That's often the problem.
I've got one for you that I wanted to talk about today. What about embellishments on a resume?
Well, there's the famous case whose name I can't remember. This is one of but this guy was an MP, and he wrote down that he had a degree in law from Oxford, INT. And he purported to say that was an international. It was what it really found out. He had no degree from Oxford. It was intermediate. He had one course or something, and that led to his departure, I think, from Parliament or something. But clearly, lying on a resume for a material fact, I think, is easy cause. Frankly.
Like a basic qualification, like do you have a
Well, it's got to be a
degree or not?
material fact. If you said if you're applying for the job of a CFO and you say you love reading books, but you really don't, I mean, who cares? Right.
Right.
But,
What if you said you're the director of operations and it turns out you were the assistant director of operations?
Yes, or you lie about academic degrees. It has to be material and presumably relied upon by the employer. So yeah, resumes are another expense accounts and resumes you can really.
But isn't that strange? Like of all the things that most commonly become cause, like these are the things that we see often, right? Like, isn't there an issue there?
I don't know if you've seen, like, how long is that going to be relevant? Because I remember having a conversation, and I think it may have been with our late friend Justice Eklund, and I'm pretty sure it was him. And I'm pretty sure what he said was, yeah, but if you've employed the person for 5 years since then, and they've done a perfectly good job, this is not going to be cause. I think it was him. It may have been Justice Sproat, but one of them said that.
Yeah, I've had people lie about all sorts of stuff. I had one mediation. In the course of the mediation, the guy put in a claim for mental distress, and the other lawyer said, "I want to see the psych notes." And this lawyer actually read the psych notes. And in the psych notes, one of the things he said he said, "I've been living a lie for 30 years. I've always told people I have an MBA," and he didn't have an MBA. And then he tried to tell me in the mediation that it was a typo. I said, no, you don't. What your fingers just went to MBA, and then on a whim, I said, "Can I see the resume you're currently using to look for a job?" And he still had his MBA there. So
It could have been a typo. Maybe he said he was in the NBA.
yeah, the MBA. No, he wasn't tall enough to be in it. No, I think if there's credentials and you lie about them, I think that's an easy cause. I'm not sure. Well, 10 or 20 years later, but if the answer is we would never have hired you.
Yeah, I wonder about that. I wonder how long that's valid cause, but like otherwise,
Yeah, no, you're right. I mean, some things fade out. It's kind of like, what if you found that he had an expense account from 12 years ago?
right? Yeah, well, I agree, but I think in that case, if you couldn't prove any fraud since then, yeah, like, there's no way that's going to be cause.
So I got one more thing. I want to talk about process a little bit when you're trying to create some evidence as an employer, or you're trying to demonstrate cause, right? So one of the things in this case was there was a lot of discussion about credibility, right? Who was more believable, Ms. Jones or the Mr. Mechalchuk? And I think that's interesting to me because, of course, there shouldn't be a contest of credibility as to what was said at a meeting, whether it was an ambush or otherwise, because there should be two people at the meeting, right? And so I thought that it was very interesting that the judge spent a lot of time talking about the credibility insofar as the two participants at that meeting were concerned and what was said at the meeting. And so I'm just wondering, what are your thoughts in terms of, evidencing dishonesty, or you're expecting, to confront an employee and you're expecting perhaps to not get the truth?
Do you ever watch British crime dramas?
My wife and I watched CSI.
All right, well, British crime dramas, they always show the person comes in with their solicitor and they sit down, they have a tape recorder, and they turn on the tape recorder. And that's what I used to tell employers to do.
Really? You don't find that's a two-edged sword?
No, you openly record. It's ridiculous in today's world. We're having arguments about who said what to who. Just take out your iPhone openly and record it. And you say to the employee, "We're going to record this so there's no misunderstanding as to who said what." And then you hit record. I don't know why we can't record. No, we'll have stupid notes taken by people and we'll fight over it. press the record button.
I've had a lot of success with recordings. Like employers, especially in owner-managed businesses, sometimes they can't resist going a little too far.
Or the employee, as long as the employee does it openly. This sounds like it's going to be an important meeting regarding my employment. I would like to tape record this. May I tape record it? If they say no, then you use that as, then when they try to say he said this, I offered to record it and he denied it. Judges love tape recordings because they don't have to listen to all this crap and decide who's lying and stuff. They just hear it for themselves.
I was going to ask you, Stuart, do you think that having two people from the company is better than just one person at the interview?
Well, I think ideally I agree with Barry, have one person and a phone recording it. So I agree on that. But I guess, now we're talking about, as you would put it, Chris, the ambush meeting. But I think the credibility issues often arise at, like in this case, the dinner. Who said what, and did she approve it, did she not? Where presumably nobody had their phone on the table recording all that conversation. So you're still going to have some credibility issues.
Is there anything else that you guys want to add on this case or on cause generally?
Use the term that Sarah may not understand. I said tape record. I think it's just record. I'm not. We used to have these machines that did this.
Yeah. I actually used to have one of those.
Reel-to-reel tape recorders?
Oh yeah.
Oh,
And all the tape would come out. You'd have to swirl it back in.
I had a client once who, he was in my office and he started asking me questions really weird, like, so, Mr. Fisher, you're guaranteeing me that I get 24 months? No. You're saying, what are you talking about? And halfway, he had this old briefcase right on the desk, and all of a sudden, I hear this whee sound. I said, what's that sound? What sound? I said, the sound of your tape recorder hitting the end of the tape.
I feel like that was a Seinfeld episode.
Oh, was it? Well, Seinfeld copied me because it happened before. So, yeah. No, but it's got to be done openly because that leads to a whole nother problem is tape recording your employer or your colleagues surreptitiously just cause. So you really want to have to avoid that problem.
Yeah, but if it's a formal meeting, I think that putting your phone out on the table is a great place to make sure that if we're doing serious stuff, let's do it right? So I think that that's got some power.
Yeah, that does. This is a surreptitious recording, and we've already seen that case at least once where it became cause when the guy thought he was actually building his own case.
And the employer knew nothing about it until they saw the guy's affidavit of documents.
That's a great example of how recording is great, but not recording everything and everyone at all times.
Didn't he say he was recording it because he wanted to learn English better or something? That's some really stupid excuse.
Yeah, but it was excessive.
Yeah.
Like there were a lot of recordings and conversations that people clearly did not intend to be either part of the workplace or recorded.
Yeah, these were personal conversations. That was way over the top. So, anyways, to answer your question, Chris, the only other thing I would add is, I have this conversation with employer clients all the time. They suspect an employee engaged in misconduct. You can't just, fire first and ask questions later. Investigate properly, and investigate, not prosecute. Those are two very different things. And then, when they then say to you, well, he's just going to lie anyways, as I said before, if he lies and you can prove it, you've just made your case for just cause even stronger. But you're going to be in a far better position to investigate first rather than find out later what you didn't know.
And most people don't know how to ask proper investigative questions or follow-up questions, so they usually screw it up anyways. Or as Stuart says, they ask completely leading questions or something, or they don't do it. So it can help the employee by saying, I tried to get my 2 words in twice and they cut me off, and here they weren't really caring. So.
But to Stuart's point, I think it's really well founded, right? Like if what you're trying to actually demonstrate is that the relationship is at an end, that it's unsustainable, giving somebody fair notice, bringing them into the meeting, knowing what it's about, having them, try to explain or give you their best answer, and it still doesn't pass the smell test. When you're standing in front of a judge or you're in court saying, there's a pattern of conduct here that's ended the employment relationship, that's breached the trust, aren't you in a better position, if you've given sort of every opportunity to the employee to get it right, and they've still chosen wrong. They've still chosen to lie, right?
The fear of the employer is they're going to concoct an answer when you give them if you give them the questions ahead of time. They're going to think up an excuse. They're going to get around it. They're going to they're gonna, oh God, I have a problem with that one. I'll say I forgot. And
But
you do
it's
get a
a-
more spontaneous answer if you just ask the question. But
Fair enough, but what is the purpose? Is it ambush or is it investigation?
no, the
right?
purpose is always to terminate the person.
That's unofficial. You know,
It's not just oh, thanks, Frank, for your conversation. They're always out to terminate the person, and whether they can build cause or not.
so I'll give you a really interesting story, and I know we're running late on time, but this kind of it's a great scenario, and this is a real life story, and it was long enough ago that I can talk about it. Right around this time of year, a client of mine at the front of their warehouse had a big holiday gift box, and people could make donations and put in toys and whatever. And one day, a bunch of toys were missing, and they were trying to figure out what happened. And they went and checked the video because they had video of the lobby, and the video showed the director of HR going in when the receptionist was on lunch and nobody was there, going in and picking out their most expensive gifts and taking them back down the hall, presumably to his office. So they were all set to fire the guy, and I said, "You got to confront him," and they did. And his explanation was, I was worried because I knew there was nobody there over lunch. We have customers coming in and people coming in and out. I was worried somebody's going to steal the really valuable toys. So I put them in my office for safekeeping, and I was going to put them back. And maybe that was a really good lie. Maybe that was the truth. In this case, they gave him the benefit of the doubt. But that's a great example of what can happen if you investigate. You may still be wondering, but at least you'll know what the defense is going to be.
Right. And, heaven forbid, that's what the guy was actually trying to do. You shouldn't lose your job, no pay, no EI benefits, because you're trying to do the right thing.
Yeah. And in that case, he was a 20-year guy, very well respected, honest. He probably was telling the truth. So you're right. That would have been, imagine if they had gone ahead and fired him. Imagine
Did they not go back to his office and say, show us where the stuff is?
Yeah, and it was there. I mean, the problem was it could have been there because he was going to take it home. It could have been there or because he was going to put it back. So they didn't really know, but they gave him the benefit of the doubt. And if they'd fired him and they were wrong, that would have been a huge severance claim and a huge bad faith claim.
Yes. So at the end of the day, the appeal was dismissed. They found that the plaintiff's conduct was such that Galaxy Motors' loss of trust and faith in him was justified. So the judge correctly considered Mr. Mechalchuk's position and level of responsibility. He assessed the severity and misconduct and found that in all of the circumstances, termination of employment for cause and without notice was justifiable response by the employer. Do we have any final words or notes from the panel?
I think we've covered it. I think we've given a few employees a few ideas about what to say and what not to say. We've given employers a few ideas about how to proceed and how not to proceed, and I hope that's helpful. What I'll say is, from my perspective, is that dishonesty, once it's proven, is probably the end of the employment relationship, and it's probably the end without a payment. And so whatever the employee may be thinking, just remember, it's not just about the package you might get from your employer, it's also EI benefits, and it's also the stigma associated with a cause termination. For example, Mr. Mechalchuk's name will forever be associated with these events, right?
Well, only people who read this case like us. I'm not hiring him. So.
The millions of people listening to this podcast.
Well, not millions, not yet, but soon. But what I would say is,
He's probably got another car dealership job right away.
I guess the one thing I will add is not every instance of misconduct is just cause. Like, I still have way too many employers who catch someone doing something really innocuous and want to throw them out with no pay. And I still, when I'm mediating, I still see defenses of just cause when it's just such a ridiculous stretch that it's a waste of everyone's time and a waste of the digital paper we're looking at. So, the threshold for just cause is still high. It was established in this case, but there are lots more cases where it's not.
all right, well, I'm going to end it there today. Thank you very much to the panel. Sarah, thank you for keeping us on track. Thank you to our listeners for tuning in. If you enjoyed the episode, subscribe, leave a review. If you've got a case you'd like to discuss with us or you want us to discuss, send it in or share your own story of workplace drama. We love a good story about workplace drama. You can email us at watercoolerjustice@gmail.com. And until the next time,